From the beginning of Montana's distinctive yet troubled history, the Treasure State was dominated, both economically and politically, by powerful outside interests who shipped in capital and bought control of the state. Historians tell us that as the Anaconda Company and its friends ran Montana, economic and political power flowed out into the hands of distant capitalists and corporations. Policy was determined in far-off New York City, and control of the press was rigid. Anaconda's corporate dominance in Montana's political affairs was unique in American history. For its first 75 years, Montana was a one-company state. But then big winds of change roared across the Treasure State. Between 1965 and 1980, Montanans ripped off their copper collar, transforming Montana from a corporate colony into a free, modern state. The people finally controlled their own destiny. The pitched battle between the people and the established power structure was not easily won, but fired in a crucible of change. A new Montana was born. Join Evan Barrett and real history makers of the time as they shine a light on this remarkable era.
Welcome back to In the Crucible of Change. We have a very, very interesting program today. You know, we are a nation of laws and not of men. We always say that, and it has real meaning. It's through our government that we write laws. It's through our government that we enforce laws. It's through our government that we interpret laws. And that interpretation belongs in the judiciary branch, the courts of our systems, our nation and our state. In addition, the fair and equal treatment under the law is an important element of what happens within the judiciary. So writing and creating the right kind of judiciary was one of the important functions of the Constitutional Convention in 1972. So we're going to dive into that today. But in addition to that, we're going to take a look at a current threat to the independence and the fairness of the judiciary that is rising to the surface today, and that's in the form of partisanship, huge amounts of money, and huge amounts of anonymous money, sometimes called dark money, flowing into judicial races. So we have a pair of extraordinarily talented folks helping us out here today to peel away the layers of these issues around the judiciary. I want to welcome Gene Bowman. Gene's been with us once before. Gene was originally from Billings and was a Constitutional Convention delegate. Not just that, but you were secretary of the convention. You were one of the officers of the convention.
Correct.
And you happen to be able to serve on the Judiciary Committee. So you are actually, you're the surviving member of the Judiciary Committee right now.
That is also
We would have picked you anyway to come here.
Oh, sure. That's, it's okay.
But by gosh.
You had no choice.
Yeah. But you know, you were there when we were debating these issues. Now, after the experience of being in the Constitutional Convention, Gene went to law school and graduated from college, went to law school, became an attorney, was a clerk of the Montana Supreme Court, practiced for a little while, and then kind of slid into the hospital foundation work as an attorney and doing that kind of work for many, many years at St. Pete's here in Helena, in Bremerton, Washington, and then also at St. Pat's for many years in Missoula.
Correct.
And you're retired to Missoula now.
I am.
But you're coming here regularly to help us sort through this
I love it.
Constitution. We appreciate it. We do. And joining Gene is Jim Nelson. Jim is a retired Justice of the Montana Supreme Court, and we welcome you here with your expertise and your experience. Jim is a native of Idaho, graduate of the University of Idaho, into military service during the Vietnam era. And then when he got out, he went to George Washington University Law School in D.C. at nights, working during the day, our kind of guy, blue collar all the way. Came to Montana to become a participant in his father-in-law's law firm up in Cutbank area.
Correct.
And Wilbur Werner was his father-in-law. Many of us remember Wilbur. And he started that in 1974, and you stayed in practice there until 1993. During that time, you spent, was it 17 years as
14.
14 years as a county attorney as well, as often is the case in Montana. Sometimes the county attorneys have to carry a little private practice to keep a living going. But in 1993, you were appointed to the Montana Supreme Court by Governor Roscoe, and you served on there. You stayed on there until 2013. Correct. So you had 20 years, and you ran for re-election twice unopposed and once opposed, but you were with us for that period of time. And I would say a very distinguished justice of the Supreme Court.
Thank you.
And I've always enjoyed your opinions and the logic behind them. And one of the things that I always liked about you as a justice was you took the position that the law said you should take, not just based upon your personal feelings about something. And that's the kind of thing we need to have in the judiciary, to have it treat people fairly under the law.
Correct, yeah.
So here we are. Thank you for joining us. And the old Constitution, by that I mean the one that was done in 1889, had a really, really, really long judiciary clause.
It did.
Tell us about that, and then what was the outlook when you started digging into it in the Judiciary Committee as to how to simplify it and make it into something contemporary?
Well, the old Constitution had a judiciary article of 33 sections, as I recall, 33 or 38. It was quite long. It was also quite full of statutory material, which is to say very detailed explanations of how this was to happen and that was to be done and so on. The new Constitution Judiciary article has 13, I believe, sections. Mm-hmm. And the committee was split 5-4. The 4 people who were in the minority really wanted to get rid of all the statutory material that was in the article. Some of it was actually not bad, but it was statutory and very detailed. And when you try to change a constitutional provision, it's quite difficult. Changing a statutory provision can be done easily by the legislature. They meet every 2 years. And so we wanted to clean that out, make a nice square box that had the outline of what a good judicial system would consist of, and ask the legislature to fill in the blanks.
Mm-hmm. That was your objective?
That was our objective.
And you had an interesting committee that you were on.
We did.
And in fact, there was, one might wonder about, you had minority and majority, it came out as minority and majority reports when you got done.
Yes.
So there was a significant division.
There was a significant division which we could not close, but I will say that I don't think a lot of effort was made to close it. And very early on, we were just not very close in what we wanted to do. So the 4 of us in the minority wrote one proposed judicial article, and the 5 people in the majority wrote a different article, and theirs was not very scaled down from the original 1889 mm-hmm. Constitution. Mm-hmm. Ours was much shorter and briefer.
So the 5-person majority, it would be fair to say, was very status quo oriented? Very
status quo. That's very, very good way to put it, Evan. Yes, they kind of liked it the way it was. I'm not sure they were all that anxious to make any changes, but they were not anxious to make a lot of changes.
Well, you know, it's interesting that you know, that it would kind of work out that way. That now I like hearing about this in this manner. There's maybe a little mythology about the convention, that everybody came there, they sat alphabetically, they held hands, sang Kumbaya, and wrote a wonderful document.
Well, to a large extent, that's true.
And yet, clearly there had to be give and take and
Certainly.
Push and pull inside this convention. And clearly it must have happened in this article in a way.
Well, I think one of the things that happened was that we did not ever, as a committee, sit down and discuss what exactly we wanted to do. how did we want to change the article? Did we like it the way it was, and so let's go have a beer? Or these are the kinds of things that we need to get rid of. These are the kinds of things we need to change. We never did that as a full committee.
So the committee didn't establish a frame of reference, so to speak, for the whole thing.
That's true, and there wasn't an awful lot of collegiality within that committee, which was unfortunate, but that was the way it was. I think probably there was less collegiality in that committee probably than any of the others.
Yeah, I guess maybe sometimes we take lessons of life from all kinds of different places. It would all strike me that there's a good lesson in life that leadership can make a difference.
It absolutely can. It definitely can.
You know, a different person, not condemning the leadership,
no,
but a different person leading a different way might have had you all pulling in harness
well, and
together.
I would say that Ben Berg, who became the leader of the minority committee, that's what he did. He said, okay, what is it that we want this thing to look like when we're finished? And that's the only way you can do it. Once you know what everybody wants it to look like, then you start making adjustments and compromising and offering, well, what about this and what about that? That didn't happen in the committee, in the whole group of committee. The other group, and of course I wasn't there, but their article came out very slightly differently than the original article. So either they never had this discussion, or if they had it, they said, gee, it's pretty good the way it is.
Did they were they kind of written separately? I mean,
yes, oh yes, they definitely were written separately.
You were off in one room, almost like you were in one room and someone else in the other room?
Yes.
Wow.
Well, the people that wrote Article 2, the fundamental
right,
rights,
yeah,
that would appear to have had a completely different leadership.
Oh, I would
because
say it
that was
did.
very visionary.
And there was a lot of give and take in that committee. Nobody didn't like anybody. It was, well, I don't quite agree with that. How about this? And that was a marvelous committee. They worked very well together, and the result is they came out with a very good article.
Yeah, Larry Edelson and Fritz Snyder, I think, in their book about the Montana Constitution, say that there's some 17 rights protected in Montana's Constitution that are not protected in the federal Constitution. Right. Different rights.
We have we did a very nice program on that with the chairman Wade DeHood and with the staffer Rick Applegate.
Yeah.
And they really had a great discussion of that, and that maybe is the hallmark of our Constitution. You know, that Bill of Rights or Declaration of Rights.
But that's what happens when everybody works together.
Yeah, exactly.
And so in your case, your committee, they didn't. So coming out of the gate, there was a question, well, what is this supposed to, how's this supposed to play out on the floor? Because all the 100 delegates had to consider it.
Right, so each delegate got a copy of each proposal. And Bruce Brown, delegate from Miles City, moved that each committee present to the floor of the Committee of the Whole a brief outline of what their article said. So Dave Holland, who was the chairman of the committee and the majority, gave his outline, and then Ben Berg from Bozeman gave his outline of our minority proposal, and then Ben moved that the Committee of the Whole debate the minority opinion, and that passed.
It passed. It may have passed because the way he described the framework was the kind of thing people were looking toward instead of this excruciating detail.
I think you're exactly right. Most of the delegates to the Constitutional Convention really wanted to make major changes. Yeah. And of course, the other one was a lot more work to go through section by section by section, reviewing it on the floor. But in any case, the irony of it is, however, that ultimately it's a mixture of the two, but frankly, there's more of what was in the majority report than what was in the minority report.
It seems like by doing it the way it evolved, that the shorter framework was opted for to start with to review it, and then they stuffed in it key elements of
Exactly.
the majority thing. They ended up dropping all the superfluous, unnecessary, detailed stuff from the other one by virtue of stuffing some of the key points of it into the shorter
I
one.
think that's an excellent description of what happened.
Yeah.
So you never know.
What does they say? Lawmaking is like making
It's like
sausage
making
or something.
sausage,
Well,
that's
this is
right.
maybe a
Now,
high-end sausage.
in defense of this sausage, though, it's still better than what we had.
Yeah.
I will say that.
Yeah.
It
You're-
has some good points.
I do run into folks who have some disappointment about it, but there were a lot of elements that came into to bear on this. One of the elements that was common in a number of articles is the question of election. Election of judges versus non-election. How many people in the executive branch are you going to elect? Those were bones of contention. And in other articles, they seem to have wanted to opt for, let's not take away anyone's voting because it might help us lose the Constitution. And was that now? So let's get to the core issue. Election versus non-election of judges was one of the major issues you guys dealt with, wasn't
Absolutely. It was probably the major item that we dealt with. And people feel very strongly on each side of that issue. And I am much in favor of appointing judges. And our Constitution is it's not a pure appointment system, and it's not a pure election system. It's a real muddle, and Jim knows this as well as anybody. And so it's hard to say what we have, but it's not pure what
No.
we have.
Well, and I'm a good example of that. I was appointed to the court, but to keep my seat up there, I had to run 3 different times. So I've seen it from both sides.
If he had been elected in the first place, it would have simply been an election. We knew nothing about him except maybe we liked the way he looked. So we voted for him. By being appointed, he had to go through a certain process of questions and so on. So it puts judges on very unequal panels of, an elected person may be the best for the job, but we have no way of knowing that. Theoretically, if we've interviewed a person before he's appointed, we know a little bit about him.
Well, you go through the judicial nominating committee.
So in effect, you got about half your wish through the
Indeed.
Judicial Nominating Commission, because that was
And
a
that
method.
was a new addition.
That was something new in the Constitution.
Yes, yeah.
It used to be when there was a vacancy that it was just the governor did it, and he just did it.
Correct.
If he liked your blue eyes,
Or,
you got named.
or maybe your pretty wife, or who knows.
Or just a friend. I always remember my favorite appointment story is not with the Judiciary, but it's with when Tim Babcock was governor, and his lieutenant governor was Ted James of the same party, but they were elected separately, and they had disagreements, and there was an opening in the Public Service Commission. And in those days, when the governor left the boundaries of the state, the lieutenant governor had all the power. There's none of this 2 or 3 day thing or any of that kind of stuff. And so Tim left the state, and Ted appointed Ernie Steele to the PSC while he was gone. and
he could.
And he couldn't rescind it. It was, and Ernie Steele got reelected a few times after that too. But while we're on this appointment versus election, let's take a little segue here for a second and talk about the general premise of that, recognizing that we opted for election with a variation through the Nominations Commission whenever there was a vacancy for appointment. But Jim, you recently did some writing about the election versus appointment, having gone through all these processes. Kind of tell us what what was your venue for writing that, and what you were looking at.
Well, to be short about it, I had always been a very strong proponent of elected judiciary because I felt that it was good that that people who are justices and judges would get out and mix with the voters and get out of their
Kinda like ivory towers.
get ivory
Yeah,
towers
yeah.
and get out there in the field and find out what people think of them. And it's a tough process. I've did it 3 times, and it's tough. But in 2010, and we can talk probably more about this later, but in 2010, of course, the U.S. Supreme Court decided in the Citizens United case, which basically unleashed the floodgates of money into elections, both elections for all the branches, and in those states where judges are elected, which is about 39 states, it unleashed the floodgates of money into those elections as well. And I changed my mind about merit system versus election because of this flood of money coming into the election process. It has really, in my view, corrupted the system, not only in the election of judges, but the effects that money has had on judicial decision making, both in the civil law field and in the criminal law field.
And
Well, we're gonna-
perhaps
go ahead.
respect for the judiciary.
Yes, yeah.
Well, we're going to dive into that in some detail
Right.
here in a few minutes, but but at this point, at least partially because of the money situation, you're now more favorably disposed toward the appointment.
Yeah, the article that I wrote for the Montana Lawyer, which is the state bar magazine, I advocated setting up a pure merit system. And I think it's somewhat different than the Missouri plan that Gene was talking about, but if it were adopted, and it would take a complete change of Article 7, by the way, an amendment to the Constitution to have that adopted, I think that it would go about as far as we can humanly go to get politics and money out of the judicial selection process.
I'm intrigued, but I won't ask. I'll just pose it here kind of fun, maybe facetiously, which is the constraint on constitutional amendments being limited to a single section of the Constitution. When you say to fix it, you almost have to do the whole article.
Yeah,
It's a conundrum.
you'd basically have to repeal Article 7 to begin with,
Maybe.
and then replace it with something else.
Okay.
And
So there's a way.
there's a way to do it, and believe me, the devil is always in the details. And as you very presciently point out, the drafting of that would be a major undertaking by people who are actually a lot smarter than I am. So.
Well, some things let's get back to the Constitution before we go back into the big money challenge to the judiciary, and take a look at some of the things that happened in there. Again, recognizing, Gene, that your framework was adopted, but the innards of it
weren't quite what we
were
wanted.
modified substantially.
Correct.
So you had elected judges.
Well, we also had kind of appointed judges.
That's
we,
true.
We had a mess. We had a little bit of each.
Yeah.
Kind of a stew.
Yeah. Well, I'll bounce this back to you. You went through the process
Yes.
of nomination by appointment with a screening, and we should describe how that works. There's a nomination commission appointed by the governor and the Supreme Court.
Well, and there's
And the judges.
and the judges.
And
And
the
the judges.
legislature.
It's made up of it's a pretty bipartisan sort of a group of
So all the
multidisciplinary group.
okay, so you got a group that's balanced with judiciary input, executive input, and so on, and then out of that, they interview people and they give the governor 3 to 5, as I recall.
They take applications, which are a lot more complex now than they were when I was appointed. They interview the candidates, and then, as you say, they make a recommendation of from 3 to 5 to the governor. He typically chooses one of those, or she typically chooses one of those. They don't have to. He can appoint somebody else if he wants. But the governor typically chooses from the
I'm going to ask you a
nominees.
history question. Is it typically, or so far has he always chosen?
So far,
one of those?
always.
So
Okay,
Yeah.
okay. It's pretty precarious political position to be in not to, I think.
Oh, I would think so.
But that process, you went through it. Your sense of it?
I think it was a good process. I think that the committee did a good job of screening the candidates. In my case, I believe there was 5 submitted to Governor Roscoe, 5 names, and they were all good attorneys. They were experienced attorneys, and one of the people, in fact, was a gentleman who later went on the Supreme Court, was elected to the Supreme Court. So they had a good mix of people, and the decision by the governor is.
Now, in a sense, the theme of our entire series here is about a change from to the empowerment of people and away from the power being totally in the hands of the vested interests or the Anaconda Company or the powerful economic and political interests of the state. In this period, there was an empowerment of people, and in essence, that process, as opposed to one where it's just who could get the ear of the governor, was probably emblematic of some empowerment of people. There's a process here that looks very fair and very balanced.
Well, the committee, and Gene makes a good point, practically anybody can run for the Supreme Court. There's some minimum constitutional qualifications, but they're not.
They're minimum.
They're minimal. Anybody can run for the Supreme Court. Typically, these races are under the radar. People don't know a thing about who they're voting for or not voting for. Typically, people ask an attorney they know, or maybe a judge they know, who's this person, would be good on the court or not, or she, or whatever. And it works that way. But they're really under the radar elections that are made with a great deal of ignorance. Things have gotten worse now since Citizens United because of the interplay of money into this. So the screening process that you go through to get appointed takes into consideration a person's experience, a person's character, a person's things that they've written, legal memoranda, briefs, arguments that have gone to court. If they're a judge, they take into consideration the opinions that the judge has written. So you get a good discussion and a good analysis of who this person is and would they be qualified to sit on the court. And you don't get that with the elected process.
Well, Gene, can you want to hit on a list of other things you guys accomplished in there that you were happy about or unhappy about? I think we were considering thinking about, you have elected clerk of the court, which was something that you didn't want, but we kept them elected.
Well, I think that elected people, elected officers, should be representing somebody or something. Therefore, we have to have elected legislators. The clerk of court is an administrative position who keeps things straight in the court. And we felt like the court should be able to interview and name the person they wanted for that position. But we lost that debate. One other thing that we wanted was that we wanted the Supreme Court to have rulemaking and supervisory control. We felt that there is really not a court system. Each court was kind of acting on its own. And this did not happen. I believe that's now an amendment. It has been incorporated into the Constitution now, but at the time we passed it, it wasn't. And that was
you were just ahead of your time.
Well, right. We did not want to retain in the Constitution the Justice of the Peace Court. We wanted to
as a constitutional
entity. We wanted the legislature to define what kind of inferior courts the state would have. We lost that one as well. And in retrospect, I'm not sure that was a bad thing that they put it back into the Constitution, that the convention did. And then though the minority wanted very much to have strictly appointed judges on the merit system. And we didn't lose it completely, but we got messed up in a stew. And I'm still not happy with it. As a matter of historical fact, at the time of the Constitutional Convention, a majority of our judges and Supreme Court justices had been appointed, even though we had an elective system.
And that was always there, because
Yeah.
if somebody died in office,
If somebody died in
or
office,
whatever,
they had to replace him.
If they
Yeah.
retired.
And historically, that had happened more than people were elected. And
So it's always been a hybrid in a
it's
way.
always been a hybrid, but not acknowledged, really. Well, we elect our judges. Well, okay, maybe we do. But,
Well, and I think that happens in since the Constitution, where
Same thing. isn't
Oh,
it?
yeah, a
indeed it
judge will
has.
retire midterm. A lot of them with the idea in mind that, well, I'm going to retire now so that Governor X can appoint my
Well,
replacement
exactly.
because I like Governor X. And-
because they can control the way their replacement is
yeah, and then
replaced.
and then the
way they're
and then of course, once you're appointed, that creates an immediate incumbency.
Which
And-
has inherent value.
Yeah, and in judicial elections, being the incumbent is always
Exactly.
is always a plus.
So
we-
the Nominations Commission became a way to continue what was an already established process of hybrid process, but a little more fairly.
Maybe legitimize it a
balanced.
little bit and
Yeah.
make it fairer.
Well, if you think about it, I mean, if you make, that's an improvement of significance.
Well, it is.
And how well the judiciary runs, the basic bottom line of that thing is, how do you get effective people in? And at least through the Nominations
I think
Commission,
yeah. I have not met, of course, all the judges in this state by a long shot, but the ones I have met have to a person said how they hate to campaign.
Oh, yeah.
That's not what they really want to do. Now, somebody running for the legislature really, hopefully, does want to campaign. Hopefully wants to talk to you and ask you what you think. How do you think this, da-da-da. But that's not what judges do.
It's antithetical to your whole mindset as a judge, that I'm not going to take positions on things. I'm going to.
It's not about popularity.
I'm going to let the law
Yeah.
and the Constitution and the facts of a case dictate my decision. And
And
yet,
sometimes it may go against your personal wishes.
many times. But that's what being a judge is all about. It's fairness, independence, and impartiality. Those are the three hallmarks. And to the extent that you screw any of those three up, you weaken the integrity and the dignity of the judicial branch of government.
Well, the only thing you have to answer to as a judge is the law.
Correct.
A legislator has to answer to his constituency.
Exactly.
And if he doesn't answer the way they like it, they'll get rid of him.
All right.
Yep. Now, another hallmark of this was the Judicial Standards Commission. That was a new entity. Prior to that, I'm trying to remember what the enforcement mechanism was, whether it was, but the Judicial Standards Commission was put into the Constitution, and it's the vehicle by which disciplinary proceedings are done in an organized manner.
Correct. And that commission is basically like, I would say like the prosecutorial and the decision-making
Kind of
vehicle.
the HR of,
It is.
of the court.
Complaints are funneled through the GNC, and then that body hears the complaint, makes a decision, and then makes a recommendation to the Supreme Court, and the Supreme Court actually imposes the discipline.
They do it.
Yeah.
Yeah.
But it, as originally provided for, it was open to the public. We were big on having everything transparent. But in 1980, a constitutional amendment said that the proceedings are confidential except as provided by statute. And I don't know how the legislature implemented that, but there's some times that it doesn't have to be confidential, apparently. But we felt like that was worth confidentiality.
Once an actual complaint is filed, then it becomes public, at least the allegations in the complaint. The deliberation phase of what the JNC does is not open to the public, and I've always been an advocate of transparency. I think that ought to be open to the public. And
there's that little balancing act.
Behave, doesn't it? When you know that the
well,
whole
and it
state is
not only
looking at-
that, but it holds the people making the decisions accountable
Exactly.
for their decision-making process.
that there really is something there.
Yeah,
worth
if they just get into a closed room and cut a deal and cut corners, that's not what this system should be
Perish
about.
the thought that anything like that could ever happen. But, well,
you
you
don't
know.
want it. It's not going to happen in Montana, Evan.
Now, how about terms? How about the terms?
We increased the terms from 6 years to 8 years, and we
For-
for Supreme Court justices.
So they used to
and-
be 6.
Right, and now they're 8, and the district court from 4 to 6. And
So as distasteful as elections are, you don't have to have them so often.
you don't, right. Well, and you know, there's such a especially if you're going to elect judges, jeepers, they're going to be spending a lot of time running for re-election. They need to be spending their time thinking about cases, and giving them a longer term on the court we felt was a
Well,
good idea.
and that's a good point, because in 2004, when I was involved in a
Competitive race.
very competitive race, I spent more time on the highways of Montana than I ever did in Helena in the courtroom. I'd have people driving, and I'd be reading briefs in car and making phone calls, and it was brutal.
That's
My
what
wife swears it took 10 years off my life. And I think she's right.
And you were forced to do that.
Oh, I had to do
because,
it.
Yeah.
I had to do it.
And that's a dumb way for him to have had to spend his
I
time.
lost the primary in that race.
I recall
And
that.
I the next morning I went in and sat down with my clerks, and I said, here's the deal. I said, if I don't start campaigning full time, I'm not going to have a job, and you're not going to have a job. So I'm really
So
going to
suck it up and help a little more.
Suck it up. You're going to be doing a lot more work than you did. So, and they did. They did a good job.
Yeah. Interesting side note to this, that there were an interesting advocate inside in testimony before the committee to try to have the elections be partisan. Would you mention that?
Yes.
Because I found that to be quite interesting.
Common Cause advocated for partisan elections, and neither side bought that.
Yeah.
I mean, as if elections weren't bad enough, then when you start saying, well, of course the Republicans think this way and the Democrats think this way, you've really lost it.
Now that's an interesting segue into some of the things under Citizens United, because while we rejected it soundly here, and it was really odd that Common Cause advanced that, although I suspect it's because they maybe thought, hey, they're Democrats and Republicans anyway, we kind of all know it.
But you do kind of wonder, and of course
Yeah.
this was 2 years ago, and I'm willing to bet they would not feel that way now.
Well, let me tell you something, though, about that whole business. Elections are nonpartisan. I think they should be, and if for no other reason is that it doesn't lock a judicial candidate into some party platform. If they were partisan, it would do that.
Right.
So if you're nonpartisan, it doesn't do that. When you get on the bench, the public isn't so stupid as not to know, well, this fellow was a Democrat or this fellow was a Republican. We have a justice on the court now that was a Democratic legislator. We have a justice on the court now that was a Republican legislator. So, people know those kind of things. But having said that, and I can tell you this honestly, from my 20 years of experience on the court, all the decisions that we ever made, all the discussion that we ever had, and the deliberations that we had in deciding cases, I can tell you that politics did not ever come up once, not one time. People had different judicial philosophies, they had different views on things, views of what the law was, but politics didn't enter into our decision-making process, and I'm very proud of our court for that.
Now, Citizens United some of the follow-up decision-making on that has opened the door that if it's not for the filing in a partisan way, it has opened the door for political parties to endorse in the nonpartisan races, hasn't it now?
That's correct, and that was
we had a prohibition on that in Montana.
We did, but there was a case out of Sanders County that went to federal court, and the federal court said that as part of the
free speech
of Citizens United, political parties can endorse judicial candidates, and that again is one of the reasons that I've now come to the belief that a pure merit system is the best way to go.
Mm-hmm.
Well, I can also say that never in the Constitutional Convention did politics become an issue.
Yeah.
We sat alphabetically, as you've mentioned, and nobody said, well, he's a Democrat, you can expect that. No, that never happened.
In fact, I find when I'm sitting around with remaining delegates and they start thinking about so-and-so was a Democrat. No, wait a minute, he was a Republican, you know. Because,
I know,
because
it just didn't matter.
That idea of, and I have to say that unanimously everyone has said that idea of not having that line down the middle, you sit on one side and we sit on the other, contributed to the product and ultimately its passage too.
And I don't think that will work in the legislature. In fact, it probably shouldn't. But I think for the court, it definitely should not be political.
Well, just a little sidebar on that thing too, though, is that the predominant opinion of Constitutional Convention delegates, though it didn't end up that way, was in favor of a unicameral legislature, and the only one we have in the United States is in Nebraska, and it's nonpartisan. So you never know, but it didn't prevail because it was on the ballot, remember, and rejected pretty soundly.
Well, I think some of these local races for county commissioners and some of the
now the local,
they're starting to go make them
most of them are nonpartisan.
Yeah.
And the argument is, what's Democrat or Republican about how the garbage is collected?
Yeah.
Yeah.
It's pretty hard to make an argument that
filling potholes.
Yeah.
You know.
Striping
grading the roads
streets
or whatever.
Yeah,
sure. Okay. Well, you know, let's bridge over into the Citizens United thing, because we've kind of talked quite a bit about some changes we made, which were modest improvements on the '89 Constitution. There was a great simplification that occurred.
Indeed, there was.
But there's some things that were improvements, some things that didn't happen, but thrust upon us from the federal level, the U.S. Supreme Court, is through Citizens United and subsequent decisions, is some pretty challenging times for the judiciary in terms of impact of money, and heavens to think money could impact something politically. But when the politics are judicial politics, it impacts those kind of decisions. Jim, this is something you've dived into pretty heavily since you've left the court.
I have, because I think it is the biggest threat that the judicial branch of government faces right now is this dark money and the super PAC money that is driving not only the election of judges, where they're elected, but it's also driving the way judges make decisions. And I guess I could, at this point, cite to two empirical studies that I have them here.
Because it does go with when you have, once the money was always there, but it was always constraints, limited. But once it became unlimited and powerful, the impact was more than just to get elected. It started to impact decisions.
Right, exactly. There's two studies. I'm just going to throw them out on the table here.
I'll hold this up so they can maybe
these
take a
were
look
both
at it.
empirical studies, and by that I mean they're actually studies that are based on evidence and analysis, and a lot of number crunching. Data from all 50 states is involved in these studies. Both are sponsored by the American Constitution Society. The first is a study called Justice at Risk. It's written by a law professor at Emory University by the name of Joanna Shepard, and that study demonstrated that as regards the civil justice system, money coming into judicial races affects not only who's elected because of campaigning and negative ads and that sort of thing, but it also affects the way judges make decisions. And not surprisingly, the more money that is spent for or on behalf of a judicial candidate, the more likely that person is going to vote for the people that gave the money when it comes time to make the decision. The second, and that was released in June of June of 2013. The second, called Skewed Justice, was just released last October 2014. Same sort of empirical study written by Joanna Shepard and a fellow by the name of Michael Kang, who's also a law professor. That study dealt with how judicial decision-making is effective in criminal law cases. Now, keep in mind that our Constitution protects the rights of criminal defendants to a great extent. And every one of us wants that sort of protection if we're charged with a crime or our loved one is, we go before the court. What this study showed was that at least in marginal cases, and a lot of them are marginal cases, the judge is going to look over his or her shoulder before voting on the case, because you make an unpopular decision, what you're going to be faced with in the next election is these flurry of Willie Horton type ads. Mm-hmm. That happened in the last election between Justice Wheat and Larry Van Dyke. One of the negative ads that ran against Wheat was that he voted to, I believe, release a person that beat his wife or something like that. They never tell you anything about the case. They never tell you anything about the context. They never tell you anything about the law,
heaven forbid,
that governed the judge's decision. All they tell you is this soundbite result. And of course the public says, oh my God, I don't want to vote for somebody that's letting child molesters and criminals back into society. They're out the window.
So the result of that kind of potential for money to be used against you in negative advertising
it
creates an artificial harshness, perhaps?
It creates a paranoia that is of concern when the judge says, well, this could go either way. It's going to go this way because I'm not going to be saddled with this decision during the next election. That's
or I
how
could
that
give
works.
you 5 years, or I could give you 15.
Yeah, although
is it in the sentencing or not?
It's
or more the guilty.
So far been the studies involved the high court, the appellate courts.
Oh, okay.
I'm sure it makes the same difference in the trial judges too. I mean, and you point out a good example of.
Now, in the case of the first study, the Justice at Risk study, assumedly, people putting big money into judicial races have an economic interest.
Sure.
And then that's often the nature of cases that come before the courts, where you're balancing that economic.
It is, and I've talked to different groups about this, and I can't cite to anything because it's my own conclusion, but I think it's an accurate one. Right now, because of Citizens United and the money that flows into political races all over, state level, national level, corporate America pretty much owns the legislative and congressional branches of government. They pretty much, in most states, own the executive branches and the presidency. That's pretty much a foregone conclusion. If these groups, the Koch brothers, the Americans for Prosperity, all these shadow groups, if they want to control government completely, they've got one branch to go,
left.
and that's the judicial branch. And if you can control the judicial branch, you have no more checks and balances left.
Yeah.
You've got complete control of government. You've got an oligarchy. You can do what you want. Mm-hmm. And that's what they want to do.
Mm-hmm. And that's about economics.
That's about economics, and it's about money.
And right now, I often think that our final line of defense for rationality and fairness is in the courts. And if you lose that...
If you lose that, we all lose. And
exactly.
Just about 99% of all cases in the United States, actual cases, are dealt with by the state courts, not the federal courts, but the state courts. Mm-hmm. That's where the rubber meets the road. And if these groups can control those courts, they've got control of. There's even U.S.
in the most recent Supreme Court race we had in Montana, which was in 2014. which ended up being incumbent Mike Wheat, who was running for the first time after being an appointee, against a fellow named Van Dyke, who was originally a Montanan, but had been out of state and somehow came back in, and he had huge amounts of dark money going for him, and it included I want to mention a Republican Party organization that's now formed.
Well, to be fair about this,
both sides had money.
And this, incidentally, was the most expensive Supreme Court race in Montana history. That one race, upwards of $1.3 to $1.5 million came into that race from the outside. That amount of money dwarfed what the candidates themselves raised, which is $250,000 or something like that.
But it forced the candidates to do some big advertising that they would not have otherwise.
Right, and there was a lot of negative advertising. The Wheat had, I think, around $600 and some thousand in PAC money. Van Dyke had some $400,000 from the Republican State Leadership Committee, or SLC, and the Koch brothers organization, Americans for Prosperity, threw in another $200,000 into his race, and then there were some incidental PACs that threw money in on both sides too. But 1.3 to or nearly $4 to $5 million, $1.5 million came into that one race. Now, the scary part is this: that was one race. In the 2014 election cycle, or 16 election cycle, we've got 3 seats up on the Supreme Court for election. Justice Pat Cotter is retiring, so she's going to have an open seat. The Chief Justice is up for election, Mike McGrath, and Justice Shea, the incumbent, is up for election. So you got 3 seats there. And it doesn't take much of an imagination to realize that if some of these organizations want to change the ideological makeup of the Supreme Court, if they want to control the Supreme Court, you come into Montana, you drop $20 million into these races, and voila, you've got a whole different Supreme Court.
By the way, that amount of money, as much as it is in Montana terms, is chump change.
It's chump change in some of these other elections.
Often the large organizations look at Montana, pardon the term, but they call it a kind of a political cheap date.
Mm-hmm.
We can get by without spending too much money. 1.5, 1.6 million, not too much money.
Million here.
Yeah, and guess what? And so, are we for sale is an interesting question.
Yeah, it is.
I think it came to the fore pretty strongly in the last election, and it became almost a subject of the election, but you never know. Money buys advertising. It's scary. It's pretty darn scary.
Oh, sure. These people, they've got, and these are very experienced organizations. I can tell you, having been through the process, it's hard work to produce a good TV ad.
Yeah.
I mean, and it's expensive.
And it takes a lot of time.
Oh, it takes people and equipment, and just for the ordinary run-of-the-mill candidate like I was, it's an impossible task almost. But these people do this for a living. They've got high-end marketing firms and videographic firms that they can turn these ads out in a heartbeat.
Now, we just got, some people would say lucky, but maybe where it's fortuitous, maybe it's just good skilled legislative activity on the part of the governor and a formed legislative majority. It was represented the kind of middle of the road of both parties, that we just passed a law that at least, if it holds up in the appellate courts, eliminates the darkness of the money, although it doesn't eliminate the amount of the money. Is that right?
No. Yeah, the Disclosure Act, I think, is a good first step, and that was passed by the last legislative session in a very nice bipartisan effort. I suspect it will be challenged in the federal courts, and what's going to happen, I don't want to try to predict at this point, but there is that. It doesn't affect the amount of the money either, you're right. And a lot of these organizations can always figure out ways around it to keep people anonymous. Corporations, General Motors, some of these corporations, they give a lot of money, but they don't give it directly. They funnel it through trade organizations and PACs, so you never know that XYZ Corporation has
Well, and
spent $200,000
I
on somebody's
suspect
race.
they're a bit careless in trying to follow through to see exactly how their money was spent.
Oh,
I may
yeah,
be wrong, that's a guess, but it wouldn't surprise me.
Now, let me just jump to a couple quick issues. We're getting close to the end here. There was a little dip of the toe into the water on public financing that John Schultz did,
Yeah.
but it didn't have any traction.
Well, he got a fair number of votes, but not enough to count. He proposed an amendment from the floor. He was very much in favor of electing judges. And one of the arguments that was given was that it's expensive to run, judges don't want to run, and so on. So Jack Schultz proposed that judicial elections be funded by the state. And that failed.
But that was
And
part of his way
That
to
was
push people
right,
toward
to
elections.
push people towards elections. It got rid of the argument that judges don't want to have to spend money or ask people for money. And so that part, we still got election of judges, but we lost the fact that the state was going to pay for those elections.
Now, another issue that came that evolved out of this thing, out of the Constitution, was the 5-member court eventually became a 7-member court.
Yes. We said in the report that was adopted that the legislature could increase the number of court up to 7. And they did that.
And they did pretty rapidly, I
Yes,
think.
they did that I think in the very first
Now, having
session.
sat on the court, now you practice, but having sat on the court, what's your sense of the go 5 to 7? Has that been a good
Oh,
move?
I think it was absolutely necessary. At the time it was done, the court's caseload was quite a bit higher than it is now. But when you've got 7 different people up there, I think you get a better mix of opinions and discussion, deliberation, and I think you decide better cases.
You also, though, have the ability to deal with more cases, and we had a caseload problem for a while, didn't we?
Yeah, and that's been pretty much resolved. That's when Chief Justice McGrath came on board, that was one of his efforts right off the bat, was to get the caseload down and to get
Caseload,
the
and
backload.
the use of mediation and
Yeah.
arbitration and stuff has helped a lot too.
Yeah, alternative dispute resolution has reduced the caseload, and as I've mentioned to you before, I think another thing that's reduced the caseload, which is not a good thing, is that litigation and hiring attorneys has just become so
Costs a lot of
prohibitively
money.
expensive that ordinary people can't do it.
Well, because we don't have an intermediate appellate court, everything that is submitted to the Supreme Court has to be heard by. They don't have the option.
Unlike the U.S. Supreme Court,
exactly.
they don't say, "We're not going to take this
sorry,
up."
buddy, we're not going to take your case.
They gotta take it.
They have to take it.
The U.S. Supreme Court writes about 75 opinions a year.
How many does the Montana Supreme Court write?
Anywhere from 300 to 400 a year.
Well, it's time for us to wrap up what is a very interesting discussion. And it is of great import to every citizen of this country that our judicial system operates fairly on behalf of everyone. That's the hallmark of one of the hallmarks of our democracy. And it's a bit frightening about the challenge that we've been talking about, the money challenge. Isn't it interesting that money is such a big challenge? We appreciate your sharing with us your wisdom and experience from the convention, your wisdom and experience from serving on the Supreme Court. It looks like we're in good hands for the time being, but I guess we have to be vigilant about the money in politics. So thank you for joining us, and for you watching, thanks for joining us in the Crucible of Change. We'll see you next time.